that. But with all the public comments over the course of the many months and other things that are happening outside of the board meetings as far as advocacy, I wanted to make sure that we had our legal counsel provide a little bit of training, and so the best way to do that is basically come in as an agenda item and go over things specifically directly, so the trustees get the benefit of that. So again, this is our meeting. We called him in to provide some of the information directly to us, and with that, yeah. So what we'll do is we'll let Dan introduce himself with credentials, all that sort of information before kind of doing the review of the Elliott Larson Civil Rights Act and things that are relevant to what we've asked him to have ready for us. Dan?
Yes, can everyone hear me?
We can.
All right, very good. So good afternoon, everyone. I'm Dan Tuckle. I'm a shareholder in the firm of Butzel Long. We've been serving essentially as the outside general counsel to the college for a number of years. I personally work with the college on employment and civil rights and labor matters. And I was asked to talk a little bit tonight about the legal requirements or the legal prohibitions with regard to use of the restrooms on campus. As many of you know, there's a state civil rights statute, the Elliott Larson Civil Rights Act, which in many regards is broader than some of the federal anti-discrimination and civil rights acts. And under the Elliott Larson Civil Rights Act, you cannot prohibit people, well, let me put it that. The Elliott Larson Act was fairly recently expanded to include as protected statuses sexual orientation, gender identity, and gender expression. And that makes the state civil rights law broader, or at least explicitly broader, than many of the federal anti-discrimination statutes, some of which have been interpreted the same way, but aren't worded exactly the same way. So under Elliott Larson, with this expanded definition of what are protected categories, you cannot preclude someone from using the facilities on campus, including restrooms, based on their gender identity or expression, even if that gender identity or expression is different from the gender that may have been assigned to them at birth. There are single-use restrooms on campus, I understand, and those nobody can be required to use those in lieu of allowing them to use the general gendered bathrooms that they prefer to use, but they can certainly be told that there are those single-use restrooms, and that's true for people who may have a gender identity or gender expression different from what was assigned at birth, if they prefer to use a private one, or alternatively, if somebody is concerned that somebody who may express their gender different than the gender identified on the restrooms, they want their own privacy, they can be directed to the availability of single-use restrooms, but they can't be required to use them. I know that there are a number of people who don't like that, but that is the current state of the law. Just like you're not allowed to discriminate based on certain protected statuses, whether people agree with that law or not, that is the state of the law. So the college needs to be careful not to preclude people or allow people to be harassed, discriminated against, or mistreated in any way because of their gender identity or expression, including in the use of restrooms or facilities. And of course, if somebody acts inappropriately, regardless of their gender or their gender identity or gender expression, that's a different matter. And if they act inappropriately, apart from simply using a restroom, if their conduct within the bathroom is inappropriate or violates any type of college policy on their conduct, they can be disciplined the same way that any other person would be disciplined for violating a code of conduct, but not simply by the use of the restroom. Many of the federal laws, including Title IX, have by at least some courts been interpreted the same way, even though their explicit language isn't as broad. But many people may simply not realize that the state statute is broader and was recently amended specifically to include these broader definitions of what is protected and what is not. That's a summary really of where the current state of the law stands with regard to the use of restrooms. I understand that the college is expanding its physical plant and to include some additional single-use restrooms and to ensure additional privacy within the broader bathroom facilities. And that those are good ideas, but it doesn't change the state of the law and what is otherwise required. It may alleviate some of the objections that the college has been hearing about, but that it's simply an accommodation. It's not a workaround or an exception of any sort. I don't know if there's anything else you'd like me to address. If anybody has questions, I'm happy to try to address them.
Before we have the trustees, do you want to give the part of your board report update of what he was referring to as far as the more multi-unit restrooms and some of the things you're doing? Okay.
So to enhance safety on campus, we currently have in place some partitions, privacy partitions that will be added to the restrooms, and that's in my board report. They were ordered, I think, some weeks ago, and finally they're in, and they will be installed to provide additional safety and additional privacy in all of our restrooms on campus. Yes, the gaps will be covered. Jack? Yes. Jack's team ordered that, and when does installation begin?
It started, they've already completed Campbell, and they're moving on to other buildings now.
Okay, so it started already.
Yeah, I want to make sure that that was cleared up. Well, we still had Dan.
In the CTC now, we're building another restroom, private restroom, building additional restrooms.
Okay, so part of what he was adding there is what Dan referred to as adding extra single-use restrooms in there. So I'm gonna go to the board first, because we invited him into the board. So do we have some questions? The board, and this isn't a one-off, so I think Scott has his hands up. We'll go to him in a moment. But Trustee Dowler?
Thank you, Chair. Can you hear me? Can you hear me? Got it?
Yes.
Yes, barely.
Okay. So my question, first of all, thank you for joining us. My question for you is, a lot of the conversation that's been presented to the board and questions by the community and the public are around signage. Is there anything relative to the signage that's referenced anywhere, or is that completely up to public institutions to determine how to address this to make sure that we're in accordance with the law?
There's nothing specific in the statute with regard to signage, and I guess there's two aspects of signage. There's one with sort of branding a restroom for a particular gender or not, and then there's signage that talks about the college policy. And there's no specific language in the statute that requires or prohibits signage in either regard. There are some suggestions, certainly there are some forms of signage that depict images of sort of stereotypical images of males or females, and there are some that are a combination, I guess, of both that are sort of disfavored. But there's nothing that indicates that you are not allowed to identify a restroom as a women's restroom or a men's restroom. There's also nothing that says you either have to or are precluded from putting a poster or a sign by the restroom, as I know the college has done in some regards, indicating that people can use the restroom according to their gender identity, and that people shouldn't discriminate or make anybody try to leave. You're not prohibited or required to put those signs up, but you certainly can, indicating what the college policy is. Does that answer the question?
Yeah, thank you.
Certainly.
Any other trustees? So if a visitor or a student comes on campus and they see a sign out of the restroom that says men, a sign that says women, what should they know that mean? What should they know that means when they go to use that space? What my question is referring to, there's a large percentage that I would assume, based on conversations, based on public comment, there's a large percentage of people that would assume those spaces mean something different than college policy and state law that you described. So are they, I know those signs aren't required, but is it helpful to inform people about those spaces? Because here we have policy laws that are kind of ahead of a large portion of public awareness. Do you get what I'm asking?
I think I know what you're asking. Yes, I think that there should be signs that identify them as men's restrooms or women's restrooms. Now, there are some, I will say, there's some public accommodation areas as well as some institutions of higher education that have gone to essentially non-gendered restrooms and simply say anybody can use all of them. So that's an option, but since that's not what the college is currently doing, I think it makes sense to brand or label restrooms as male or female. And what that means is that people who identify as either male or female, or presumably as neither, can use those restrooms. They may not understand that means that somebody who might have been assigned male gender at birth but identifies as female might also be using the women's restroom. They may not understand that from the sign. I'm not sure that there's a way to do it other than to indicate, which the college can do, but again, isn't required, to put some kind of notices by restrooms or publicize it generally that restrooms can be used by whoever identifies as the gender that's labeled or identifies as neither gender. So that policy can be publicized. I don't know that it's the most effective way to do it, to try to educate people by how the restroom is labeled. But it would be helpful for people to understand that when it says women's restroom, that includes people who are biologically women, who are women who are assigned the female gender at birth, or who identify or express themselves as women, even if they might have had a different gender assigned at birth.
Then, if I'm getting you too much on the spot, let me know. But in the last couple of weeks, a group from Michigan, Greater Education Initiative, or I'm not sure if I'm saying that correctly, but they filed a Michigan lawsuit for Title IX nationally. And I think the plan there is if it's challenged and some things aren't upheld as far as that goes, that their plans are to go and challenge Elliott Larson locally. If I get into some of those conversations, when we just talk about the narrow issue of bathroom use, the question of religious exemption, I'm a conservative Christian, and I have a conservative Christian daughter. Does she have a religious right to have a restroom that's a multi-stall restroom to be just female or just male? Like, are we going to have an issue with state law not being legal in that regard?
Well, I would say, first of all, with regard to Title IX, Title IX is one of those laws that has been interpreted, at least by some courts, to include protected categories that aren't explicitly listed. And there have been some challenges under Title IX to use of restrooms by people who identify as gender other than what was assigned at birth. And there have been lawsuits in various states around the country in that regard under Title IX. There have been injunctions issued in some states about that. But Elliott Larson is broader than Title IX. So regardless, even if it were to be conclusively determined that Title IX does not go as far as allowing people who have gender identity different to use restrooms that were assigned to the other gender, that doesn't affect Elliott Larson. So whether or not the college will have issues with it, I mean, there's nothing that stops somebody from bringing a lawsuit, whether it's a lawsuit or a civil rights charge against the college or against any other entity challenging the law. And that may happen. There are certainly have been proposals in the legislature to modify the law, to make it broader, to make it more narrow. Those have not passed as of this point. I wouldn't be surprised if there will be challenges. There often are when there's a new law. Interpreting it, and for example, things like signage. There may be lawsuits talking about whether certain signage is appropriate or violates the law or not. That will shed further light on how these laws will be interpreted. But right now, that's the state of the law. And I think if anyone wants to engage the board in a discussion about challenges, what I would say is that the board is following the law and will continue to follow the law as it evolves. And if the law changes, we'll follow the law as it's changed. With regard to religious issues, I think that the short answer is no, that religious belief would not allow someone to compel the college to provide restrooms that cannot be used by other people. There are religious accommodation requirements that are similar to the accommodation requirements for people with disabilities that are protected by law. So you do need to reasonably accommodate religious beliefs, but you can't reasonably accommodate them by violating what the law says that you have to do. And an accommodation does not have to be the accommodation that even when it's legally required, doesn't have to be the accommodation somebody requests. It has to simply be any reasonable accommodation. And there are often more than one reasonable accommodations that would be satisfied. And I think here, a reasonable accommodation would be to tell someone who says, my religious beliefs don't allow me to use a restroom where somebody who was assigned a different gender at birth can also use them. I think a reasonable accommodation would be, as I know the college has done in the past, to say, we understand that there are a variety of single-use restrooms around campus where you can have complete privacy. Here's where they're located. And if your religious beliefs make you prefer to use one of those, you're welcome to do so. And I think that would be sufficient if somebody were to bring a challenge of that sort. It doesn't mean they can't bring the challenge, but I think they would have a hard time succeeding when there are already accommodations available through the use of single-use restrooms.
Trustee Dowler, another question.
Thank you. For clarity on the Elliott Larson Act, what is the breadth of impact? So is it all public institutions? Is it high schools, middle schools, daycares, jails, prisons? What is the breadth of that?
Well, Elliott Larson has 3 different sections. One that applies to employment, one that applies to, it has at least 3, but one that applies to places of public accommodation, and one that applies to institutions of education. And a place of public accommodation is defined to include an educational institution, certainly a public educational institution. And an educational institution is defined to include any educational institution. Again, at least unless it might be a religious institution. And those various sections apply broadly to a whole range of different types of entities. So it may very well be that places like City Hall and other places like that are subject to one or more of those provisions. Any place really that welcomes the public and allows the public to attend is typically, unless it falls within an exception, a place of public accommodation to which this same rule would apply. And public educational institutions are also places to which it would apply. And the definition of what is prohibited conduct for a place of public accommodation includes prohibiting somebody from the full use of a variety of aspects of the place of public accommodation, including facilities, services and facilities. And facilities certainly, I think, would include classrooms and restrooms and other physical parts of the campus. So there are some exceptions to what might constitute a place of public accommodation or an educational institution that wouldn't apply to the college as a public institution. So I can't tell you that every different facility would automatically qualify, but I think it's clear that the college would fall under one or both of those definitions.
I have a follow-up on that, so just so that I'm reiterating clarity on this topic. So in our public middle schools, as an example, an individual who identifies differently than their birth gender can utilize the restroom that they identify with, just as we have here at the college. Is that correct?
Yes. If it's a public school and there's at least one case that went to the Federal Court of Appeals for the Sixth Circuit, which governs the federal courts in Michigan and a number of other states. There was a case like that, I believe it was an elementary school case actually, where there was a transgendered student and the court allowed them to use the restroom. The circumstances were somewhat different, but the restroom to which she identified, even though it might not have been the restroom for the gender assigned at birth.
Thank you.
Scott, is your hand still up?
Yes, and this is just a quick, because it's been mentioned several times. So Title IX, one of the things that I've been talking about for a long time is that Title IX was rewritten and went into, the new rules went into effect on August 1. However, as Dan pointed out, there have been several injunctions. It's really a college by college basis to stave off the new Title IX regulations, in which case if the school is mentioned within the injunction in Kansas City specifically, then they must still abide by the old Title IX regulations, and we are a part of that. So I just want to make that clear. I don't know if Dan wants to add anything more to that, but just that everyone has awareness.
No, Scott, I don't think I have anything to add, except that to some extent, whether Title IX reaches this issue or not is irrelevant because of Elliott Larson's broader application, or at least arguably broader application than Title IX.
Yeah, there's nothing in Title IX that would violate Elliott Larson or vice versa that I can see.
No, states are permitted to have laws that are broader in this regard, that offer broader civil rights protections than the federal laws. They just can't have laws that restrict the federal law, but they can be broader. And Michigan has done that, by the way, historically in a number of circumstances. Michigan law prohibits discrimination based on height and weight, which is still not a protected category under federal law, but it is enforceable under Michigan law, and Michigan has a disability discrimination statute that was very similar to the Americans with Disabilities Act, even before there was an Americans with Disabilities Act. So you can be more broad in your protections, you just can't restrict federal restrictions or reduce them.
Anything else I can help clarify? Any from the board members? Well, Dan, I'd like to also give you our appreciation for giving us your time today and explaining it so clearly. I know that it gets real technical when you start talking about Title IX, changes to Title IX, administrative rules, things like that. But I think you did explain it very clearly, our unique situation in Michigan with Elliott Larson and how that applies. But just double checking one more time with the board. We definitely appreciate it. We have missing board member, two actually here that hopefully they'll, this is kind of seen internally here. I'm hoping is a little bit of training, so I think this will be something they'll review also and get the benefit of your visit with us today. So I appreciate it.
Happy to, certainly if the law evolves or is interpreted, I'll keep the college informed of any changes.
Thank you.
Thank you.
Thank you. And that, there's no action item with that. That was just him coming forward to give us that update. So I'm gonna just keep going down the agenda here. So I'm into old business. Any old business?